Religious education is not a party. Not even one single antisocial element is made a party. No explanation is offered for not making one. If we entertain such petitions endlessly, this will go on like this. Yes.
It's better you file a proper petition. Bring the averment. There is no averment. The college is stopping you.
They may be given a liberty to file a fresh lodge.
Not even included college party. Now you have moved an amendment application. Now, what type of petition for 226 and 227 read with 482?
Yes, my lord. So due to clerical error, my lord, it is that is why I have filed an IA application for because of the situation.
Petitions are filed and time is wasted. You see.
My lords, I humbly request apology, my lords, because of the present situation.
File proper petition, we will give you liberty.
Oblige, my lord, sir, with the liberty to file a petition.
Under counsel for petition, this petition has been filed seeking following relief. The counsel for the petitioner submits that inadvertently by mistake certain errors have crept in the writ petition. As such, he may be permitted to withdraw the writ petition with liberty to file a fresh. The writ petition is accordingly dismissed as withdrawn with aforesaid liberty. Yes, next.
Number 2, Chatterjee.
My lord, I'm led by my senior, Mrs. Kirti Singh.
Please, your lordship. I'm here for the petitioner. There are two petitioners. One is a women's organization which has been fighting for the rights of women since its very inception in 1980. And the other is a Muslim woman with 3 daughters. So your lordship, at the inception, I want to point out that there was a mild error which we have attempted. We hadn't filed a declaration which is required by this High Court rules, by the Karnataka High Court rules, and we have got the declaration ready and we may file it, and your lord, it's in the court, and then your lordship will hear the matter.
Have some other office objections as well.
I think they have been removed. Is that clear, Aditya?
With my lord's permission, my lord. The office objections, one pertains to a certified copy of the impugned government order not being filed. A dispensation IA has been filed for that. Since the matter was mentioned yesterday, the defects were not marked for
20 rupees deficiency in the stamp. Second office objection. Third office objection is PIL to be filed as per Rule 14(1), accompanied with an affidavit in the form as on pro forma.
Yes, that affidavit is got to court if your lordship will permit. We'll file that immediately. And rupees 20, I think we can just ask somebody to go and get the file rupees 20 stamp.
We'll give you time to make good the office objections.
Okay, your lordship. Thank you, your lord.
For the petitioner, press for the allowed at this time to make good the office objections.
Number 3, Vidya Mohan. Lordship, appear for the petitioner. Notification issued by the State of Karnataka, dated 5th February 2022. Preamble speaks about all the schools, your lordship, all the education institutions, schools and colleges under section 133 of the Karnataka Education Act. So there are basically the issue cropped up is pertained to the first grade, the PU colleges in Karnataka, that way would be your lordship. So now, subsequent to that, this notification speaks about all the schools and colleges, including unaided private institutions also. That is what the operative portion of the notification says. So as far as these petitions are the Minority Federation Association, who have filed earlier also 2 writ petitions, and also the matter went up to Supreme Court and regarding language policy, as well as the right to education also. In that also, Pramati Education Society, one matter was there. There the court has laid down the law. As far as the minority institutions are concerned, they'll be protected under Article 29, and that is notwithstanding Article 19 to G or whatever, wherever the restrictions are imposed. So in support of that, I want to relay only 3 judgments, which based on which this petition is filed. If you Lordship permit, I will only short note whatever it is there. I will just point out only 2 paragraphs here.
Who is the petitioner?
Petitioner is the Karnataka State Minority Education Institutions Management Federation, under which there are members of the institutions, education institutions, wherein both ICSE, CBSE as well as the Christian schools also their members.
It's a registered body.
Yes, Your Lordship. Yes. That is also
under the Society Registration Act.
Yes, Your Lordship. Yes, Your Lordship. That registration certificate number is also there. It is there. I can just.
Now, where is your?
It was registered in 646 of 2006-7 in 2006 and 7 in the year.
No, where is the authorization? Where is the resolution? You are filing the writ petition
Yes,
on behalf of the society.
Yes, Your Lordship.
Is there any resolution of the society authorizing anybody to file the writ petition?
Chairman himself is filing the petition. Chairman himself is filing the petition.
So no authorization is required in
Not because we have filed several writ petitions before the court earlier also.
Show the bylaws.
Yes, sir.
Whether the chairman is authorized.
No, I have not stated that. Now, what I am saying that
I think you have annexed.
we have been filing these petitions. There was no objection as far as
This
Yes, sir.
writ petition on behalf of the society is not maintainable like this.
Then I will produce the authorization letter. There is no
What you will produce
problem.
when we ask the question, then you people
Yes, sir.
say you will produce it.
Because all along when we have filed several
Why at
petitions,
all we should maintain this?
no,
petitions?
several writ petitions we have filed, Your Lordship. In none of the writ petitions, this issue did not crop up.
This is something very, very shocking. This is
No, I'm not.
no reply.
Sorry.
That till now you have not been asked this
No,
question, so therefore-
not on that. Because we have also produced registration certificate in other matters also.
We have a series of division bench judgments which say, in all
the society would not be maintainable unless you first show the resolution of the society,
Please.
taking a decision to file the writ petition, and thereafter the authorization
Yes.
in favor of somebody on behalf of the society to file the writ
Yes, sir.
petition.
Yes, sir.
These are the basic 2
Yes,
things.
Monday-
You say that this question has never cropped up.
Monday I'll produce it. I'll produce the
No,
authorization.
you will not grant you time. There's not.
Because the problem is that, Your Lordship, the urgency in filing this petition is that the 5th February notification which has been ordered.
You should have been careful in filing the writ petitions. This is no way of filing the writ petitions. You are unnecessarily wasting time of the court.
Even earlier also the associate management of primary and secondary schools also they have
And
several
when you
petitions
put
have
the
been
question,
filed.
you say that this is for the first time question.
And the matter to constitutional bench also of the Supreme Court. That's why.
This is a settled
No,
position.
Your Lordship, I will just produce that authorization letter, Your Lordship. Kindly have it on Monday. I will produce that authorization, including the registration number.
Something very,
You've got all the writ petitions which I filed also. I will furnish you.
You made a
Kindly
mention
have it on Monday.
yesterday, you made a mention, we made, give you the permission,
Yes, sir.
everything has been done. But look at the way you have filed the petition.
We are only concerned about the notification which has been issued, wherein the problem has started now where every schools and colleges also. In fact, Your Lordship order be confined to para 11, when where a CDC of the college management authorized letter, I'll produce it. Minutes of Monday, kindly have it on Monday.
Adjourn on the request of counsel for the petitioner to enable him to file the bylaws of the petitioner society as well as the resolution.
Yes.
And resolution of the society and authorization on behalf of its president to file the instant writ petition.
Yes. That one more now notification has been issued by the government, Your Lordship, circular, saying that it applies today. It has come in papers also.
You do that.
So the problem that also I will
Please, do not waste time. Yes.
please, after filing this petition, that notification came to pass.
Yes, Mr. Executive.
Yes, I appear for the respondents. Only one thing, Lordship may kindly note. On writ petition 2146 of 2022, that is Ayesha Hazim, I appear for respondents 1 to 4. The other respondents are represented by some other learned counsel.
1246.
Respondent 1 to 4. 1 to 4.
Oh, 1 to 4.
Only 1 to 4. That is the only petition where there are other learned counsels who are appearing for the other correspondents. That is Mr. Sajjan Powaya and Mr. Nagan. Let's see it now. 1 to 5. May I follow?
You appear for 1, 2, 3, and 4.
1 to 4, Lord. And as well as 1 to 4.
Not 3. 3 university.
1 to 4. 1, 2, 3, and 4. Yeah, all the 4. 1, 2, 3, and 4.
Aisha, he said.
In respect of all other petitions, I appear for all the official respondents. Yes. But in reply to the arguments which have been advanced by the friend, I will address your lordship. But as I have understood, what the controversy appears to broadly fall into 3 categories. Firstly, what the government order dated 5/2/2022. That has been called into question, but on various grounds. So my first proposition before your lordships would be that the order dated 5/2/2022 is perfectly in accordance with the provisions of the Education Act.
Yes.
Of course, what various grounds have been, I will try and meet each one of them which have been raised. Second, words, of course, is the more substantial core issue which they have raised relating to the practice of hijab as a part of fundamental right under Article 25 of the Constitution. But we have taken a stand that hijab, lords, the practice of hijab does not form part of essential religious practice of Islam. That is a stated stand of the state lords, and we will justify the same.
Just to make clear first, is the true intent and purpose of the impugned order. That's when you will argue the one.
Yes, but the third one, of course, an argument, though not so substantially, which has been advanced, is that this right to wear hijab can also be traced to Article 19(1)(a). And therefore, the prevention of wearing the same violates 1918. Mr. Hegde in his opening remarks made that submission, and Mr. Kamath relied upon two decisions in support of that contention. So the submission is that it does not do so. But it would be my endeavor and respectful submission before your lordships to persuade your lordships that all these three questions which they have raised requires to be answered in the negative. But before I address your lordships on these aspects, there is one other aspect which I must think I must place before you.
Yes.
There is one positive proposition which the state wants to place before your lordships, and what I would leave it to your lordships to decide the same at the end of these three issues. And that is, according to us, the proposition is like this: but the practice of hijab to be accepted must pass the test of constitutional morality and individual dignity as enshrined and expounded by the Honorable Supreme Court in Shabarimala and Shahra Banu's case. And I'll be in a position to substantiate this proposition. This is an independent proposition which we are making for your.
Just let's
that the practice,
note down the proposition.
Yes, that the practice of hijab, which has now been propounded,
must pass the test of
constitutional morality and individual dignity. These are the two words the lordships have used. As expounded in Shabarimala's case, reported in second chapter. 2017.
Constitutional morality.
Yes, constitutional morality.
Constitutional morality and the other thing?
Individual dignity. May I give the citation as expounded by the lordships?
All right,
yes, I leave it. But insofar as now, lordships will see the first question about 5/2/2022 government order. Of course, that order has been broadly called into question, lords.
No, on this, we would like to know what is the rationality behind issuing this government order.
True. I will come to that. I will just restate for my purposes the grounds on which it has been attacked. First, the first ground is it is irrational. Number two, non-application of mind without jurisdiction. The authority which we have created under that order is an extra statutory authority. These are the four grounds. But in fact, what I wanted to place before your lordship, the rationality behind passing the order, the background behind that.
All those things are subsequent. First, we will.
Yes. No, the
rationality of this
government. The background of the order dated 5/2/2022. We want to trace and place it before your lordships. I have now given a compilation of documents, which are fundamentally documents which are filed by the respondents and petitioners together. So what is the background as to how we reached this stage of 5/2/2018?
Yes.
But of course, this is centric to Government Pre-University College, Udupi. The first document and the second document, third document, my lords may kindly see. Lordships may kindly see page number 7, 1/2/2014. Which relates to constitution of the College Development Committee. Lords, kindly see 29/3/2013, page number 1 itself, first resolution. The translated version is at page 2. So this is the first of the document we could trace, which shows prescription of uniform to girl students in this institution. That is, lordships will find it at page 3. Lords, serial number 5. I am only trying to persuade your lordship that the prescription of uniform has been there since some time now. Kindly see point number 5. In the meeting, it is decided to change the uniform of the girl students studying in first PUC for 2013-14 batch. But this is in 2013.
You are on which page?
Page one is a Kannada version. Right? English version starts from page 2. The relevant portion is at page 3.
What is this meeting?
This is a resolution of the College Development Committee.
The fifth respondent college committee.
Yes, that's ಮೇಲ್ಗಡೆ ಟಾಪ್ ಈ ಮೇಲಿನ ದಿನಾಂಕದಂದು ನಡೆದ ಕಾಲೇಜು ಅಭಿವೃದ್ಧಿ ಸಮಿತಿಯ ಸಭೆಯಲ್ಲಿ they have used the word college betterment committee in the English translated version. It has to be development committee. Let's get page 3, serial number 5. To change the uniform of the girl students studying first QC of 2013-14 batch. Lordships have found that. Now, Lords, I will straight away take Lordships to the second of the resolution, which is relevant.
This meeting is of which body?
College Development Committee. That Lordships gets it at page 2, at the top of the
meeting. Following decisions have been taken in the
College Development Committee. That translation is not correct. It's the College Betterment Committee, Development Committee. So the endeavor is only to show before your Lordship the prescription of uniform in this institution in the year 2013-14 itself. Now, as to what was the uniform worn by the students, Lordships will get it at page 11.
1 second.
I'm fine.
What is that sanctity of College Development Committee, where such a body arises under the scheme of the Act?
Under the scheme of the Act, I'll take your Lordship. The government order is produced at page 4. But insofar as how to locate this College Development Committee, but I will be in a position to bring to Lordship's notice with reference to the provisions of the Karnataka Education Act. Now the endeavor before your Lordships is to the factually notes how we reached the stage of 5/2/2020 to that government order. But I may only point out before your Lordship that is the government order dated, the resolution of the committee dated 23/6/2018, which is at page 11. But I will come to College Development Committee. But I will be in a position to show before Lordship. It has some authority under law.
Because the 5/2/22 order,
yes,
for the first time directs constitution of such a committee.
But Lordships are aware, first time the College Development Committee is constituted pursuant to page 5 of that resolution, that book, in 31/1/2014 itself. But I thought that document was referred to by them, but the other side. Page 5, may I read that circular which was issued by the government? The Department of Pre-University Education is imparting first and second QC examination education in state pre-university education is an important milestone in the student's life. In order to make proper use of the grant sanction to it in accordance with the instructions issued by the government and department, and with purpose of developing basic infrastructure and maintaining educational quality, it is directed herewith to form college, but that has to be development committee, not betterment committee, and to function as per the following guidelines. But kindly see the members. President, member of the Legislative Assembly of the respective constituency, Vice President, local person nominated by the member of the Legislative Assembly, members, representatives of the parents, 4, among which there shall be 1 woman member, 1 SC/ST member compulsory. Second, 1 member with an interest in educational field. 3, students representatives, among which there shall be 1 girl. It is not applicable to pre-university college for boys. 4, vice principal, senior teacher of high school, division in the composite pre-university colleges. 5, senior lecturers of the college. Member secretary will be the principal of the respective college. What is the object behind this? I will be in a position to substantiate. When I come to the legality of the order dated 5/2/2008, I will be now digressing, but if I take Lordships to that.
This never challenged.
It is not in challenge by any of the respondents. But I want to point out about this concept of uniform. Lordships may kindly see page 11. This was a resolution passed on 23/6/2018. I am referring only to the English translated version. The relevant portion starts from page 12. About the uniform, Lordships will get it at page 13, item number 4. Further, it is resolved to maintain the same uniform in this year also as maintained in the last year, like blue colored chudidar pant, white colored with blue colored check top, and blue pant colored shawl on the shoulders in all the 6 days of the week. Also, it is handed over. Also, it is decided to hand over the responsibility of providing the uniform to the poor girl students from donors to the Vice President Ishpal Suvarna, and powers were given to the principal to take decision after checking the availability of the uniform in the shops. That is insofar as students who cannot afford. But the school uniform laws, which prescribe what the girls will wear, was prescribed in 2018. Even earlier it was prescribed, but this is what we got, not we are placed. Right? But there was no difficulty at all till December 31st, I'm told, not 2021, when a group of students, possibly the petitioners in these, the 6 of them, would approach the principal. This is, on fact, it has been stated in an affidavit filed by the 15th respondent to Lodges, and insisted that they will enter the college.
These are girls' schools or
girls college. It's a pre-university girls college.
Girls' schools.
Yes, girls college.
It is not co-ed.
It is not a co-education. It is girls college, and I will also give the numbers of girls we will study. How many girls are studying? But I am told this is an all-girls college and has a total strength of 956 students from class 8th to 2nd year pre-university college.
The 5th respondent college.
Yes. It starts from school. The numbers which we have, 8th to 2nd year pre-university college, 956 girls study. It's all girls college. Now let's coming back. On 31st January, December, this incident happened where some of the girls came. This is stated on affidavit, but this is not something which I am stating. And they approached the principal and the others and informed them that they would enter the institution only wearing a hijab, which led to a resolution being passed by the College Development Committee on 1st of January 2022 at page 15. But when this insistence took place, the College Development Committee wanted to consider this in all its perspective and its right earnest. And therefore, proceedings took place at page 70. This was on 1st January 2022. But I will only read the relevant portions. Others are not important. But it was chaired by the member of the Legislative Assembly along with the others, other principal, etc. Now, kindly see the first sentence. A meeting was held at 11 a.m. on 1/1/2022 under the chairmanship of so-and-so, the legislative member of Udupi constituency, who is the president of College Betterment Committee, with Educational Services Committee and parents. A discussion was held on few girls coming to college wearing hijab since a week. Since 1985 to till date, kindly note this, uniforms have been worn by all students as per the suggestions made by the parents. Educational Service Committee and College Betterment Committee, for the purpose of bringing discipline in the college and treating all students in an equal manner. No question was raised about it. But as parents of few children have requested, the Honorable Legislative Member of giving provision to their daughters to enter the classroom, it has led to discrimination among students. This college is only for women. Hence, uniform is implemented for the discipline in the college. It may lead to indiscipline if it is changed now. Parents are requested in the meeting for allowing to send their children only with uniform to college as earlier and assured that no trouble to their children's educational progress will be caused. Not in the next paragraph, kindly skip few sentences and come to that sentence which may be relevant, where it starts by saying, it was decided in the meeting. Let's just get that. It was decided in the meeting to conduct the classes as per the previous system until further orders will be issued by the Director of Pre-University Education Department. They wanted to refer this matter to the Department of Pre-University Education. Until that decision comes, we continue with the status quo ante was the decision. But Lordships will also see the tenor of the meeting. The parents of the students were called. They were told that since 1985, this progress has not been there. There would be no impediment for your education. Kindly continue. After this resolution came to be passed, I am told, and I am instructed, it did not help. They continued with this insistence or protest saying that they would not adhere to this and they would continue to wear hijab. Now, this led to a communication to be made by the government to the Director of Pre-University Education Department at page 23. My lords will also note in this letter a reference by a letter written by the chairman of the Karnataka Minority Commission, Sri Abdul Azim, on 17/1/2022, as regards this subject. Now, kindly see how the government reacts or responds to this situation. With reference to the above subject, on bringing your notice to the letter referred above, uniform has not been prescribed and not made mandatory for the students studying in state pre-university colleges. But the girl students of Government Girls Pre-University College, Udupi district, were urging to allow them to wear the clothes. Some typographical errors are there. Just may pardon me for this. Where the clothes of their choice were informed about the uniform dress code prescribed to the college while getting admission, and they had obtained enrollment in the college only after agreeing to the said information. But the issue which was not there so far has been raked up now, and this is not good in the educational interests. In the background, it is necessary to constitute, but this is a high-level committee to review the existing uniform dress code for students of various state pre-university colleges and to contemplate regarding uniform dress code for the students of pre-university college on perusing the judgments passed by the Supreme Court and High Courts of various states. The government needs to take necessary action after examining the recommendations submitted by the committee upon conducting a study. I have been directed to inform the Government Pre-University College, Udupi, to take measures at the level of the institution itself to maintain status quo in respect of the issue of the uniform dress code prescribed for girls. I'll pause it for a moment. When the government came to be intimated of this sensitivity of the issue, we said that we will constitute a high-level committee consisting of various persons. We'll examine what are the judgments of the courts and also the issues relating to as to whether what is the dress code to be given, including this issue relating to job. And until then, please maintain status quo. This was the communication we made to the Pre-University Education Department, asking him in turn to communicate it to the institution. But based on this, on the same day at 25/1/2022 at page 27. When is this? Another resolution came to be passed by the College Development Committee. At page 29, Lords, it was decided that status quo ante should be followed. Practically, there is a plea to the parents of the children. Please follow whatever has been prescribed. At last paragraph, Lords, it will lead to indiscipline, etc. Institution notes that there are more than about 900,000 students studying. Because of 6 of them, it should not be affected. Anyway, this resolution came to be passed. But I will stop here. After this order came to be passed, interestingly, this writ petition was filed at this stage itself. The present writ petition, which my lords are examining, 29/1/2022, this writ came to be filed. There was no government order of 5/2/2022. There was no further resolution on 31st January, which lordships will get it later. The prayers, of course, being 226 proceedings, I do not want to not sound very hyper-technical, but all sorts of prayers are said. Initiate action against the MLA, initiate action against the officers, etc. And some of the grounds which have been made is that the wearing of hijab forms some sort of the right under the Act. On this note, notice was issued to the state, and state was to respond. But I am told the matter did not rest there. In the institution again, this unrest continued, which led to another resolution being passed on 31/1/2022 at page 37. at page 37, is the last of the resolution passed by the College Development Committee. This reiterates the same thing, except in this, I must say, at page 38, last sentence, they make a positive assertion that children should not be wearing hijab. This has been produced before your lordships only for this purpose. He also informed that if the parents send their children with the hijab, a disciplinary action shall be initiated. That's true. But I must point out here, but this the resolution also notes something very important at page 37, second paragraph, very subtly put across by the committee. He intimated the parents that the students of all community are learning in this college, and interest of those students is very important. Opposition from all other communities is receiving due to one community. That should not be allowed. The concern of the committee is reflected in that. It was in that background where this statement came. Now, this, Lords, I'll state, this resolution is not called into question either before this court or before any other forum.
Yes.
Now we come to this very stage just before 5/2/2022. By this time, Lord, the state government was flooded with issues relating that this issue of this institution is spreading to other institutions. The issue relating to wearing hijab is turned into a religious one. The intervention of the state was therefore not called for, because it did not remain localized to one institution. It was being projected as if not the state was doing something in this matter, state was intervening in this matter. But naturally, Lordships have seen what earlier we had taken a stand that we will constitute a high-level committee to look into this, but they did not heed to that. The protests and the unrest went on. It is that background, page 42, the impugned order has been passed. Now, Lords, most importantly, Lords, but I will show before your Lordships what is the purport and impact of this order. Because one of the submissions or propositions we have made, Lords, before your Lordships is this order dated 5/2/2022 is innocuous in nature, does not interdict any of the rights, if any, Lord, of the petitioners. Lordships may kindly note this, and I will demonstrate before your Lordships why it is said so. 5/2/2022 does not interdict, does not affect any of the petitioners' rights. But when Mr. Kamath was submitting before your lordships. Justice Dixit made an observation. The orders must be read as they are. Words must be read in the which they are accompanied, and they cannot be read like statute words. I cannot put it across in any better manner than what his lordships has put. A plain reading of the order, lordships may kindly now see what it results in. Except there could be contentious regarding certain English translation, but I will not trouble your lordships on that. I will bring to lordships what is the purport of the order at page 44, operative portion of the order. Much has been made out by the recitals in the order, that also I will justify. But kindly see ultimately what is that we direct. In the light of the circumstances explained in the proposal, in exercise of the power conferred under subsection 2 of section 133 of the Karnataka Education Act 1983, the state government, this is the first statement, state government has ordered that the students shall compulsorily wear the uniform prescribed by the government in all government schools. Lordships may kindly note this one. In respect of government schools, whatever uniform the government has prescribed, please wear that. In respect of private schools, students shall wear uniform prescribed by the management of the school. This is the second.
No, the government has not prescribed any uniform.
We have prescribed. Insofar as government schools are concerned, we have prescribed in this manner. I did also find out. But what we do as government is under that Vidya Vikas scheme. In fact, children are given free dress, free uniforms insofar as government schools are concerned. And
uniforms have been prescribed by the development committees.
No, correct. This is only for schools. This is the first portion relates only to school. Second portion leads to pre-university college. I'll come to that. First portion only to government schools. Government schools, what we say, whatever we have prescribed, please wear it. Insofar as private schools are concerned, we say whatever the management prescribes, please wear it. Well, lordships may can. Second, insofar as PUC colleges are concerned, we say, lords, it is ordered that in the colleges under the jurisdiction of Department of Pre-University Education, the uniform prescribed by the College Development Committee or the Supervisory Committee of Management of the respective colleges shall be worn by the students. But I will definitely justify what is this College Development Committee, why we have it. But the purport of the order, what we say is, insofar as PUC colleges are concerned, whatever college development, I'm only now trying to bring to lordships, kindly see the state's view. We are not interfering. We are saying whatever the College Development Committee fixes, you please follow that. The next sentence is, in the event of the College Development Committee is not fixing so, but here our draftsman has become over enthusiastic, unnecessarily writing. He could have seen all that he meant was students shall wear the dress which would depict equality, unity, and public peace or reason. But they have gone into affecting law and order. All that what he meant was please wear dresses which would inspire public decency, nothing more and nothing less than. But lordships may for a moment not see the effect of it. Assuming that sentence was not there also, but it would not have made a difference to the order. So the intervention of the state lordships will now kindly see. On 29/1/2022, we said we will constitute a high-level committee who will look into this issue relating to hijab. But when it went up, we said state will not take a stand this way or the other. We said we leave it to the complete autonomy of the college development councils insofar as pre-university course is concerned, and schools are concerned to the private institution to prescribe whatever dress you want to wear.
Dress that goes well with the idea of equality and unity.
That is, yes, but what we say is, in case they are not prescribed, please wear dresses which do not very indecent, do not go against it. Something which we could have put it across in a better word, but it does not say anything more, anything less than. The question of hijab, lords, unless they want to read something which I am not able to read, but I have read it 10 times, these 2 paragraphs. Question of either asking an institution to proscribe, they use that word, or prescribe hijab does not arise. Where does the state come into picture? I'll say, but I'll bring to Lord's notice why they have unnecessarily dragged us into this, made it into an issue. When Lords, on a plain reading, 5 to 2022, state does not say whether we have asked them to prohibit hijab. In fact, we have given complete autonomy to the college development councils as well as to the institutions, private management institutions.
All right, but
No, I'll just complete this thing. After something which Lordships may kindly, after 5 to 2022, very interestingly, till this day, though my Lords are hearing them, but we have not received a single complaint about any college council or a school having prescribed any resolution which has resulted in unrest, or where our intervention has been invited.
what we want to know is that what is the background of this government order which you have mentioned before issuing of this government order? What was the necessity of all this?
No, the necessity was on account of these resolutions which came to be passed on 31st January 2022 by Government Pre-University College Udupi. And our earlier communication where we said that we will constitute a high-level committee. There is tremendous pressure upon the government to decide one way or the other what should be done. At that point of time, the government has taken a very conscious decision for not to enter this
government order is very innocuous. It only says that in the schools, whatever the uniform is prescribed by the government, that is to be worn, and in the pre-university colleges, the university prescribed by the committees, that is to be worn.
Yes. But that is
how. Come to the earlier part of this order.
Yes.
Where you have said that these considered these judgments, and then you have said that this page 44, as per the judgment passed by Honorable Supreme Court and of various high courts of different states mentioned above, directing not to attend school by wearing head scarf or covering head is not in violation of Article 25 of the Constitution. Where was the necessity to say all this?
Lords, now, Lord, by this time, Lordships have seen that. But these are what is
suggesting something.
Yeah, sorry.
You were suggesting. Why?
No, that is just what I must time before your Lordship. But we are, there could be something like we are indicating to the authorities below that you do something about it. Of course, not now. It's I can only go by what is the letter, what is prescribed, what is there, which is therefore we say an operative force. Any other suggestions which we have given it?
If we accept your argument that this government order is very innocuous, it only talks about whatever the uniform has been prescribed, that is to be worn by the children.
But I want to make this. That is the stand of the state. But today the allegation against the state is you have I'm speaking and we'll come to that other issues relating to hijab, how the school behaved in the matter. That is a different aspect. So far the state is concerned, but they're very conscious. We have consciously kept ourselves away from this. We have given it to the decision autonomy of the college development councils to decide upon the uniform, including the issue relating to hijab. Of course, there is a
meaning thereby that if the development committees decide to permit the students to wear hijab, you do not have any objection to that?
But may I respond? Yes, I will respond to that. But let us say the possibility. But there is a possibility. But the college development committee may decide that we permit hijab. But we have something called, I must point out, under section 131 of the Education Act, revisional powers. If any of the students or if any of the authorities are to come before us with a grievance that this would result in something else, but possibly the state may or may not take a decision. But as of now, Lord, the fact that in the order we give an autonomy to them, but kindly visualize another situation. So what would have happened if I had said, I'm sorry.
You mean to say another 50,000 revision petitions should be filed before the government?
No, certainly not. No, certainly not. But certainly not. But we have very consciously we are very conscious. The state has taken a stand. Appealing to the autonomy of the College Development Council to decide the issue. But the College Development Council can decide the issue one way or the other.
But you have not left that option.
But we have. But that is what, of course, now the question is how they have understood it.
No, we have understood, right? At least judges understand.
But if lordships feel that the paragraph just above the operative portion indicates that hijab should be banned or proscribed, but I will clarify, I'm not an advocate general. That is not the purport of the order.
No, in so many words, you have not stated wearing of hijab should be prohibited. You have not articulatedly put it. But for a commoner, these orders address common people, market people, punctus punctilio people. Is it not? These orders are meant for that only. College teachers, students, parents, members of the CDC. How they will interpret this? How they will?
I will answer the question straight. But I will state once again before your lordship, what is the conscious stand of the state? But conscious stand of the statement, I'm with all responsibility, I'll make the statement. Is what we do not want to intervene in these matters insofar as it relates to religious symbol issues matters in the educational institution. The reason is this: if we are to, let us say, if we are, instead of doing this exercise, roundabout exercise, we could have very well, I'm not sure what would have been its validity before your lordship. We could have very well said that on an examination made by us, let us say the order was to say, the insistence of students to wear hijab according to us would lead to disruption of a secular atmosphere in the institution, thereby degrading the academic standards. Now, I'm just bringing to light. Therefore, we direct each of the college development councils to prevent and prohibit headscarves, which is called hijab. I do not know whether they could have passed that order. But if the state wanted to do so, nothing prevented it from doing so. Why I am making this submission for your lordships? In all responsibilities, this is the stated stand of the state. We did not want to intervene. And if we lordships ask us to take a stand on these issues, possibly, that is the reason I mentioned 131. There is one provision, but if somebody comes before us, and says that they have permitted CDC, which is not, for whatever reason, possibly it may require some amount of thinking and an elaborate consideration before a decision is taken. Now, coming back, all that I am saying before your lordships is, penultimate paragraph above the operative portion does not, lordships have said that may give an indication, but my submission before your lordships is all that it records is a judgment of the Kerala High Court, Supreme Court in Kerala High Court.
What was the necessity to mention all this?
But that is
to say that this government order is an innocuous order.
The background was this SDMC, the Udupi government colleges issue, which was the foundation for this. But finally, the government took a decision. Not all that I am bringing to lordships notices, and what this state is not stating this before your lordships. By the order, we have not instructed, and we have left it to the autonomy.
No, let us let us understand the effect of the order.
Yeah.
Do you mean to say that the paragraph which Honorable Chief Justice has confronted you with,
the one which is just above the operative portion, yes,
operative portion, whether the colleges or the schools, whichever, can they ignore that and prescribe the?
May I answer?
Yes.
But I am not saying it. The government order says, the government order. You put stand which I have taken on the issue of hijab, we have filed an affidavit, and I justify before you on a different issue, on a constitutional issue.
No, that we are only on geo right now.
This issue, we have left it to the complete autonomy and decision-making process of an institution. But I cannot improvise or say something about the government order beyond what it is stated. But if this gives an indication, that paragraph, which gives an indication to the institution, it is something which the institutions must understand. But of course, that paragraph also, lordships have seen, is nothing but not recording the judgment of the various high courts. Now, Kerala too.
We just wanted to know the necessity of mentioning all these judgments and thereafter recording your conclusion and thereafter issuing the government order.
No, On a better advice, possibly those things could have been avoided, but now that they are there, but my endeavor before your lordship is, but yesterday I was thinking of this. Yesterday I was thinking of.
It appears that they do not take your advice.
No, sometimes not, it is less said the better, they say. But the government officials are very good in these things. I do not know how in this one they are always. But anyway, all that the submission which I am making before, the legal submission I am making before your lordship is the attack on this government order dated 5/2/2022, saying that is irrational, it gives a communal color. I mean, it discriminates Muslim women under 15. One absolutely is without basis. Absolutely without basis. Not only we have stated that, so my statement, lordships may record, we have left it to the institution. I have repeated it number of times.
That we have noted.
Yes.
It does not.
Other aspect, what I just
you say that it does not affect the right of.
It does not. On a plain reading, it does not.
And it is totally an innocuous government order. And government has left it to the institutions to decide about the issue of the uniform.
And my lords, and there is nothing but post facto this order. There is nothing before your lordships, wherein some committees have come before the college and said, look at the state government directed us to do so. Therefore, we are prohibited. The petitioners have not placed anything before.
Now let's come to the next.
I'll come to this note. I'll have to say something else before. Now, this order, therefore, lords, innocuous, does not contradict, therefore, no cause of action. Lords, is my kindness. Now, Mr. Kamath, lords, two submissions he made. Non-application of mind, he said. But non-application of mind, what he was trying to say was these judgments, some of them are not relevant, some of them are relevant. That's what I don't think I should not request lordships to unnecessarily digress on this, because our submission is not this. The officers sometimes record those things. But yesterday I was thinking
we will say more application.
More application. More enthusiasm is what I. But in fact, I was just thinking of a provision in civil procedure code, lordships are aware. There is no appeal against a finding. So, assuming this finding is against them, the operative portion is in their favor. The question of assailing this order, saying that the finding is wrong, does not happen. Of course not. It is on that question. That there is no finding, there is no adjudication of this.
1952 Supreme Court. Govardhana Das Bhanje versus Commissioner of Police.
Yes.
Page 16, AR 52 Supreme. That says, a statutory order, because it's your contention that this is a statutory order, referable to 133, a statutory order, if challenged before the court, its validity has to be adjudged based on the grounds stated therein and not the horse. 78 Supreme Court, an order of the government is not a wine that becomes better as the time still serves. Mohinder Singh case. 78 Supreme Court.
Mohinder Singh
Constitution.
Mohinder Singh's case, but all that I was not on the technical. What I was trying to bring to these findings, these observations made in the court, or something which do not form the foundation, because as they say, ultimately the operative portion itself decides the issue. Now, let's one other argument which has been made by Ravi Varma Kumar, the Senior Counsel, is this College Development Council Committee is an extra statutory authority, and therefore giving them the power to fix these uniforms maybe without jurisdiction.
He also said that government has yet to take a final decision with respect to that you have constituted a high level.
Yes, 29th January. That is correct. That is correct.
So the high level committee has not yet taken any decision. Government has yet to take any decision with respect to the issue of uniform.
Correct. That is correct. For this,
or at least you should have stated. We had earlier thought of constituting the committee. Now there is so much tumult in the society. Therefore, we give up that decision and make this order. That's not your case. Even in the pleadings, you have not stated that.
Earlier, that high-level committee which we wanted to constitute was in reference to number of representations we received. Now we have left it to this college development councils, but possibly the idea of continuing with the high level committee, I do not know what the government has in mind, but I do not have instructions as to whether they have given up or they still want to continue also is something which I can find out. So
whether it will not amount to that this government order of 5th of February was premature. Because once, on the one hand, you are saying that a high-level committee has been constituted and the decision is to be taken by the committee. On the other hand, you are issuing a government order directing the development.
I must say that the government, relating to exigencies of situations, etc., issues these orders, particularly in exercise of 133 subsection 2. There are arrangements which are made, but it does not have any prejudicial effect to anyone. And so, but
it will not amount to contradictory stand of the state government.
No, certainly not. The reason is not because 29th law, Lordships, I showed for your Lordship the rules. In fact, the rules prescribed it is the institution itself which has to. This 29th order was a broad-based committee we wanted to do to understand how to go about these very unusual situations which have arisen. These are not very usual situations of fixing. Normally, the government never enters into this area of fixing the uniforms for the entire state. These are unusual situation came up, and therefore that committee has been formed. It's a question of contradiction. Now we say that College Development Council shall fix these uniforms, but this is in accordance with section 133. But I wanted to point out before your Lordship's notes how this 133(2) itself has been exercised. For that purpose, Lordships may kindly see this Karnataka Education Act, statement of objects and reasons. Yes, I'll just. Therefore, I'll just. This is an unusual act, Lordships have seen it. Karnataka Education Act 83, but it came into force only with effect from 1/1/1995. Almost for 12 years, it was not brought into force. One second. Right. But preamble, shall I just read? This becomes relevant because this has to be now read in context of section 133. It's a very short one. Whereas it is considered necessary to provide for the planned development of educational institutions, inculcation of healthy educational practice, maintenance and improvement in the standards of education and better organization, discipline and control over educational institutions in state, with a view to fostering the harmonious development of the mental and physical faculties of students and cultivating a scientific and secular outlook through education. I cannot say. The act itself entirely is directed towards the betterment of the student community, to build them into a better citizen by inculcating scientific and secular outlook through education. A few other provisions, Lordships may kindly note here itself. Applicability of the Act, section. This may not directly relevant. No, I just give the overall how the Act functions. Section 1, subsection 3 makes it applicable to all institutions except what is ICSE, CBSE. Institutions maintained by those exempted categories wherein no specific provisions are made. It's been some amendment, I'm told.
They amended the act itself, bringing the ICSE. The rate of single judge.
Just Nagmohan Das. But may I draw Lordship's attention to the definition of education institution, which maybe becomes related. Section 2, subsection 14 means any institution imparting education referred to in section 3 and includes a private education. Therefore, a government institution and a private educational institutions are covered. And what is now important is Lordships may kindly note the definition of recognized educational institution. The reason is that this word appears in Rule 11 of fixation of uniform. Kindly see 2 subsection 30. Recognized educational institution means an educational institution recognized under this Act and includes one deemed to be recognized thereunder. That is what's registered, recognized, and deemed to have been recognized. But the scheme of the Act is what when a private educational institution is set up, they seek a formal recognition to the government under Section 30 process mechanism. 30. Section 30. What is Section 6? Lordships have seen Section 36. 36 relates to recognition of a private educational institution. That is what they make an application, we consider all that. But what happens to a government-run college like this PU, Udupi College, is taken care in Section 38. Not just get that, 38. Notwithstanding anything contained in Section 36, educational institutions established and run by the state government or any authority, sponsored by the central or state government or by a local authority and approved by the competent authority in accordance with such conditions as may be prescribed, shall be deemed to be educational institution recognized. Therefore, we are deemed recognized.
No, formal recognition is necessary.
Yes, yeah. So the reason why I'm mentioning this Lord is under Rule 11, they speak of a recognized educational institution which will fix the uniforms. But insofar as, since we are addressing this issue relating to College Development Council, kindly see how a private educational institution is managed. And that Lordships will get it at page 40, section 41. There is an elaborate procedure. The managing committee is at page 42. Section 42, I'm sorry, section 42. That is what Lordships are fully aware of private education, how managed. Interestingly, I'll pause it. For a government PU college, there is no concept of a managing committee. Now, kindly see Rule 11 once again for that fixation of uniform. Lordships have get that. That Rule 11 of this Karnataka Educational Institution Classification Regulation Rules 1995. Provision of uniform, clothing, textbook, etc. Every recognized educational institution may specify its own set of uniforms. Such uniform, once specified, shall not be changed within a period of next 5 years. Very innocuous provision, no difficulty, but now it has been made a bone of contention. Every recognized educational institution shall fix up. Now, Lordships have seen, insofar as the private educational institution which is recognized is concerned, has a managing committee. For whatever reason, insofar as our colleges are concerned, we do not have a managing committee. The question, therefore, before the government was, and who should fix it? When somebody has to do it to fix the uniform on behalf of the recognized education. But that was something which, in that context, in order to give effect to these rules and to the Act, we exercised power under Section 133, subsection 2, Process Mechanism 133. Of course, this is some sort of a residuary powers, overriding powers, or something which Lordships may characterize it. Subsection 2, the state government may give such directions to any educational institution or tutorial institution as in its opinion are necessary or expedient for carrying out the purposes of this Act, or to give effect to any of the provisions contained therein, or of any rules or orders made thereunder, and the governing council or the owner, as the case may be, of such institution shall comply with such. every institution. Subsection 3 also, Lordships may kindly see. The state government may give such directions to the officer or authorities under its control as in the opinion are necessary or expedient for carrying out the purpose of this act, and shall the duty of such officer or authority to comply with that. I'll just leave. Though I am tempted to cite 143 also, 142, which is power of to remove difficulties. I'll just only bring to Lordship's notice that we had to put this act into operation, this rule into operation. We did not have anything. We have direct. So what is interesting, which Lordship will note now is that college has not called into question this order. The constitution of College Development Council is not for the first time we have constituted, it is there since 2014, and it performs various other functions as well. None of the colleges have come before your Lordships or before us saying that this is something without authority. Students come before your Lordships and say that that authority is without something which is extra statutory. But that challenge itself, according to me, must fail on that ground. But to give effect to this provision of Rule 11, this power under 133 subsection 2 has been utilized. Lordships may also read the power to remove difficulty clause under section 142. And Lords, I may complete this by also stating section 7, which empowers the power of government to make rules. Lords. 7, again a residuary power has been given.
But this is not generally such removal of difficulty clauses appear in new policy evolvement.
Yes.
There, orders made under such provisions, going by the patterns of the orders, perhaps with your long experience, you might have seen them. Such orders quote that section.
No, I understand.
For the purpose of removal of the difficulty.
No, I am completely in your hands. This is something which we improvised. The Henry VIII clause concept, which we used in wherever we. But 133 subsection 2 is what we have. This is ultimately what I was thinking of. This. I was thinking about whom shall we. If I had said given it to the principal, Ravi Kumar sir would have come and said, no, he's an employee. Why did you give it to him? If I had given it to DDP, I would have said, no, he's an officer. We have given it, but there was criticism to this SDPI. CDC. I want to place on record something. But kindly look at the Constitution. There cannot be more representative character. Sorry.
So we just wanted to get one more clarification.
Yes.
The circular which you showed for constitution of
2014.
That for constitution of the College Development Committee.
Yes.
That has been issued by Under Secretary.
Yes, ma'am. The government. Yes.
Can it be treated to be a direction under 133?
The order notes of 31/1/2014 Lords. But obviously we may have to trace it to that power only. There is no other provision by which, because this has been done not in order to ensure that the better.
This is not a government order.
So this is a government order. Lords.
It is not a notification.
No, this is a notification.
It is a circular issued under the authority of Under Secretary only.
Normally, these are issued in the name of Under Secretary, but it carries the approval of, if I may say so.
We want to know.
It carries the approval of the ministers.
That is what we want to know.
Certainly, Lordships may take it from me with my experience, but this document I do not know. I can surely get that certified, but Lordships may.
The approval of the government was
concerned minister.
Whether the approval of the government was there or not on this circular.
Most certainly, yes, Lordships. I'll produce the original document before your Lordship. Should not be a difficulty. But I am very sure that a very important circular wherein a MLA of every constituency would be given this power would not have gone without the approval of the minister concerned. I will place it.
Yes.
Yes. Now, yes, all government orders are issued in the name of. But therefore, my submission, I'll also place that 2014, I will get the original record. There should not be any difference.
When orders are issued in the name of the government, the governor, in the name of
In the name of the governor, but
Yes.
that this we have this the rules not in same, just like issuance of government orders from ratification. It says in the name and by the approval. Normally under secretary issue, but this file not I'll get, but Lordship may take it from me. This would not have.
Yes.
I was just on this representative.
this clarification would be required
I will not, sir.
to appreciate your.
Certainly, most certainly. I'll get place that.
Under the transaction of business rules.
Yes,
whom
1977.
it is allocated, you have to show.
Sorry, I'm sorry, I could not.
Under the provisions of the transaction of business
Yes,
rules,
yes,
to whom it is allocated, this power, that you have to show.
yes.
Because of Parikar judgment of apex court.
Yes, Lord, I am aware. Chief Minister, Cabinet, and Minister concerned. 3 categories. I will show it. This is a very important decision. Getting the MLAs to, this would not have gone
We
without.
cannot presume.
No, I'm not for my place. I'm only saying it, some amount of experience for this guy. No, I just want to point out the representative character of this committee. Lord. There cannot be something better than this. There is the local MLA, local person, parents representation, students representation, members belonging to scheduled caste and scheduled tribe. The principal is ex officio secretary, the vice principal, 2 teachers are nominated. The entire fulcrum of the institution comes together to take a more democratic. There cannot be criticism of such kind of committees. Let us say, for instance, this hijab controversy. There will be students representative, there will be parent teachers representative. It is not that the decision is to be taken by one person. Therefore, such committees being interested cannot be under no circumstances be termed as irrational. I will leave it at that. But one other aspect, only for the purpose of record, though it may not fall really for Lordship's consideration, was MLAs must not take part in such committees, is what Professor Ravi Verma Kumar suggested. But I don't think that is our scheme. We have borrowed the Westminster model.
For governance.
Yes. It is therefore we have a political executive who are borrowed from the assembly who are executive. That American model of keeping the executive completely away from the elected body is not number one. Number two, under the scheme of the constitution itself, under Article 102, insofar as members of parliament are concerned, and 190 for members of the legislative assembly, there is disqualification attached if you hold an office of power. That is the only restriction for an MLA to hold officers. If not, there is no other restriction for him to become part of the committee. Anyway,
that is disqualification for holding office of profit. It's a totally different concept. It does not admit here at all. We are asking, they were saying, and we are repeating now.
Yes.
We are saying what they had said.
Yes.
This time, MLA from X party.
Yes.
Next election, MLA from Y party,
Yes.
Z party, A to Z, and so many parties, or independent MLAs also. Those political views will enter the campus. Is it desirable? It is not that we have no respect for the MLAs, etc.
Yes.
They are very important, and without them, there will be no government, no legislative body. But point is, MLA is a character, a more political character. This is how Ivor Jennings, Casey, where all they treat that way. Whether that character should have overtone in the administration of the institutions is their concern. Not this party, that party.
I understand.
To all parties we have got respect, and
whether politicians should enter the campuses at all.
not politician.
No, I mean,
Elected representatives.
members of the legislative assembly. Yes. Matter of course, a debate in a different context. But this one, my submission before your lordship is that it is in these circumstances why the government intervened, or rather did not intervene, but I will put it and left it to the college. But the unfortunate events which took place and the attack, but not only I am pained, but all the people concerned are pained at the way the government has been berated in these proceedings, saying that we are dictated by some other reason when we administered these orders. We have discriminated girls and women on the basis of these are not something
There is another aspect.
Yes.
If there is a MLA as the chairman,
Yes.
kindly look into the text of your order.
Yes.
MLA, he is a nominee.
President.
MLA is the chairman or president. He is a nominee, will be the vice president. Whether other members you want to, means it's their argument.
I understand. No, I understand.
That's how we have perceived.
I completely.
If MLA and he is a nominee, or two persons are holding that key position in the committee, whether the other members will have any role to play, except sipping the tea at the meeting.
Not the constitution. But I understand. I completely. I'm in lordship's hands. The viability, desirability of having them is a matter which could be debated either. Therefore, Lords, my submission before your lordship on this government order dated 5/2/2022 is, my lord, that is, it has been exercised in accordance with section 133 subsection 2. It does not interdict any of the rights. Therefore, the challenge has to fail. Lords may also note no challenge to any of these orders which have been passed.
Which orders?
That
Constitution of
2014 order. But now that lordships are examining it, I am duty bound to satisfy lordships. I will place on record the approval. What I am instructed to state is that challenge was not there, and to the committee or any other person.
Who appoints number 3? Come to Sadasyaru.
Yes.
That 31/4/2014.
Yes.
Sadasyaru. Who opts them? Who appoints them? Nominates them?
I'll have to find out whether it is done by the government or by the local committees. I'll have to find out. Let me. Because that is something very pertinent. Again, if it is given to an MLA, then there will be a group of his own persons. I'll just find out. Of course, not more contentious committees have been in the school development managing committees for SDMCs, which have there are of course a lot of issues takes. But these are not just pre-university courses, not much of work.
Now we come to the second.
Yes, second. I'll add that. Yes.
Practice of hijab is not part of
Yes,
essential.
yes, Article 25(1). But before lordships go this issue, just one sentence I want to say. Kindly see the method and manner, my lords, which the government order has been assailed for your lords. That's something which my lords, I request lordships to kindly take note. When it did not affect them, and that too, the timing 5/2/2022 is the order, subsequent to which no committees have fixed anything or there has been no controversy at all. Therefore, that is something which my lords may kindly take note of. Now, Lord, the students now say in some of the petitions, of course, in this petition, this Ayesha Hazim Almas petition, this prayer is not there. But There's one other submission I'm told. But there is provision under the Act where not students, in case they find any difficulty such to give a representation to the parent-teacher committee, which is constituted under Rule 12, and to the government under 131. No, I'm just bringing it. No student will, except for approaching your lordships directly under 226. No such.
Against what? Which order?
No, parent-teacher committee in Lords Rule 12.
No, that's all right. Now there is a government order. You mean to say the government order should be challenged before the government?
Not 5 to 2.
Like Caesar's order going to be challenged before Caesar's way.
Not 5 to 2. This grievance about not permitting hijab being worn, etc. Nothing has come before the government by way of a normal situation. That is what the normal students are expected to do.
What is that committee?
So, student parent-teacher committee constituted under Rule 12 to a redressal of the grievances of the students. Lordships may kindly see 12 sub-rule 5 to redress the grievances of the students and their parents, if any.
How you will come to know about it? Whether any student has approached these parent?
No, nobody has come. Nobody has come. The reason why I'm mentioning it, if it was a case of an uniform, these things would have followed. But I will leave it at that. I will not say anything more.
Okay.
No, I'm told not to sit there. There is no such grievances have been made. They have come before your lordship. Some of them have not come before your lordships, and of course have raised it outside. The second issue about hijab being part of fundamental rights. But they say now, first, the way they have put it across is Mr. Kamath in primarily. They say that wearing of hijab forms part of essential religious practice. It does not, this is how I want it, this does not come in conflict with public morality, rather morality, public order or health. Neither does it interdict any other rights under Part 3. Therefore, prevention of me wearing hijab violates 25(1). This is what the Learned Senior Counsel wants lordships to hold and declare and read it in this manner. May I request lordships to kindly see 25(1), Article 20. Yes.
Just want to
Yes.
refresh our memories. There was one argument by another senior advocate, Mr. Yusuf, that even if it is not treated to be essential religious practice, wearing of hijab,
Yes.
then also stopping of it would violate Article 25(1) because the article under 25(1) is freedom of conscience,
Yes.
not only religion.
But I have an answer for it, straight up.
I'll
answer that. But 25 lordships have to see once again. Lordships have read it number of times. We have made lordships read it again and again.
There is no res judicata for reading.
I have to be conscious. Pardon me.
We'll be happy reading with you also.
Just once, not just. Freedom of conscience and free profession. Justice Dixit.
Yes. Yes.
Freedom of conscience and free profession, practice and propagation of religion. Subject to public order, comma, then morality and health. And to the other provisions of this part, there is a comma. All persons are equally entitled to freedom of conscience and the right freely to profess, practice, and propagate religion rights. But this is what I was looking right from Article 12 to 32. None of the fundamental rights have a clause something like this, Lordships have kind. It non-obstantive, because if I have to say, very difficult for fundamental rights to say so, but still, Lord, it starts by saying subject to.
This is what we pointed out.
On the first day, Honorable Chief Justice pointed out that one only.
So this is something very subject to public order, morality and health. There's one other distinction I want to point out before your Lordships, but just so that Lordships will kindly see. How is it distinct from 25.2? Is, my lords, 25.2. This is something which I have noticed. This speaks of the power of the state to restrict or regulate by way of an order. Lordships will kindly see. Nothing in this article shall affect the operation of any existing law or prevent the state from making any law to restrict or regulate. 25.1 does not speak of any law to be made by the state. There is a definite object behind that, but I will demonstrate. Similarly, 19.2, Lordships, the freedoms available under 19.1 series can be restricted under 19.2 onwards by way of a law. So therefore, the 19.1 rights can be restricted, regulated by way of a law under 19, by law to be made by the state. 25.2, again, law to be made by the state. The concept of law to be made by a state is conspicuously absent in 25.1. It speaks of subject to public order, morality and health. Therefore, as I have understood, how 25.1 requires to be given effect to is, if somebody is to assert exercise of that right, I'm talking of right to exercise freedom, religion, the court, my lords, may have to examine as to whether this exercise, this right would conflict public order, morality and health. In the event of there being a conflict, my lord, those three things will give way. This will give way to those three things. That is one possibility. The second test is to find out whether or not it comes in conflict with any other fundamental rights provided under Part 3. Then the question of prioritization, which is the other word, prioritization would come. These are the way 25.1 requires to be operationalized, I put it across this. Whenever a challenge comes before the court, somebody seeking to exercise right to religion, the first test, according to me, which requires to be applied by the court would be to see whether that right comes in conflict with the public order, morality, or health. Obviously, on an assertion made by the other side. Of course, if you have to, state is to come before your lord. The question of making a law by the state and being a law under Article 13 may not arise at this stage at all. All that we have to show before your lordships is, kindly look at this. During COVID period, all the temples, churches and mosques came to be closed down. That is the essence of a religion. But for a Muslim, Mohammedan to go to a church, or for us to Hindus to go to a temple, for a Christian to go to church, it was closed down practically for 6 months, 9 months, 1 year. The reason is for health. The government, of course, they exercise the power under the Disaster Management Act, that is different, but that is the reason. Not communicable diseases. If a person says that I want to enter a place of worship, but if he holds a communicable disease, health, straight away the managing committee, the Archak, anybody can claim. We don't require anything else. Therefore, in every situation like that, the first test the court must take. Now that they have come up with this hijab, has to examine this, whether it comes in conflict with public order, morality.
Whether 25.2,
yes,
is in the nature of an exception to 13(2).
That is law, Lordship, sir, referring to law.
Not only that, 13(2).
13(2).
The state shall not make law.
One second. That we are dealing with the most sacred portion of the Constitution. I do not want to immediately react. Let me get back. But prima facie, what I would feel is it speaks of abridgment or taking away the rights. This speaks of regulating and restricting. That is one possible distinction which can be drawn. And certainly, if it is to be held that the abridgment and restriction can be equated, then it becomes a exception, but I'm not very sure. Can we draw any exception? We can draw any.
Have interpreted these.
I will examine. I'll surely examine. But I was on 25(1), therefore, the first test Lordships may have to examine. This is second test Lordships may have to examine whether this comes in conflict with any of the rights. It also speaks of, with Lordship, the Honorable Chief Justice, of very interestingly, freedom of conscience and the right to practice religion. But I did take that extra interest to understand what is freedom of conscience in this one. The first and simple explanation is what Durgadas Vasu says. I'll place it before you. Actually, very beautifully put it across. Of course, there have been a number of judgments on that. But, what he says is what freedom of conscience is something which is, you believe. Propagation of religion is your manifestation of outwardly exhibition. That is how he puts it across. And this is supported by a number of these. That is what he gives the example of Jainism, Buddhism. He says they don't believe in God. That is their belief, and matter ends there. But kindly see his very brilliant analysis at this on Article 25(2) when he is describing at 1, 2, 3, 4, fifth paragraph. Fifth paragraph in that page number. Page number 3519.
3519.
3519, 1, 2, 3, 4, fifth paragraph. Lordships, get it?
Yeah. 3519.
35. 1, 2, 3, 4, 5, fifth paragraph. Yes. As has been pointed out before, Lordships, get it? Yes. As has been pointed out before, Article 25(1) has two parts. A, freedom of conscience, and B, the right to profess, practice, and propagate religion. The religion usually assumed belief in a creator, or at least in the case of an atheist, in the existence of a life superior to our earthly existence. But there may be persons who do not believe in either of these two and cannot therefore be said to have any religion. Such persons believe in the fulfillment of human life in this earthly existence and do not admit of any existence apart from the mundane. The conscience in the case of such persons may be said to consist in non-belief. What this is for. The freedom of conscience under Article 25 of our Constitution guarantees the freedom of such belief or non-belief irrespective of the religious faith of such person. Where he has no religion, he has the guaranteed freedom to hold to his non-belief free from interference or imposition from any other person. But this is very important for this sentence, which I want to. Freedom of conscience is thus a mental concept, while the right to profess, etc., refers to external action in pursuance of such mental concept of the individual. But the Constitution gives me the freedom to say there is no God. That is freedom of conscience. What is manifested? Give me England. House of Lords. House of Lords. European Convention, Article 9. That paragraph, that particular paragraph.
Freedom of conscience is only with respect to the
Only for that purpose. What we manifest, what we practice outside, like Mr. Kamath, Mr. Kamath, while arguing, gave this example. He said, I wear Rudraksha, it is my belief. No. Belief is not wearing Rudraksha. Wearing Rudraksha is your manifestation of your religion. Believing something to yourself is your freedom of conscience. Therefore, they use the word freedom of conscience and right to practice religion. The right is something which you can enforce. Freedom of conscience, you do not enforce anything. You believe in Buddhism, you just believe it in people. I believe there is no God, but I do. So they said, you can still, in this country, we just do not want to give you to do something, practice religion. You also want to respect people who do not want to believe religion. Therefore, they use the word freedom of conscience.
You mean to say freedom of conscience is confined to only atheists?
No, certainly not. For instance, therefore, they have given the definition of Buddhism and Jainism.
In fact, there is in the Vedic literature,
yes,
there is one sloka, Prathama Pratima Puja, Japasthotrani Madhyama, Uttama Manasi Puja, Swaham Pujo. I do not do any puja at all. Because
yes,
I worship myself
yes.
lonely. So even that comes within the conscience.
No, I agree. That's exactly what I'm saying. That what you manifest outside by way of a practice is the second portion.
Not even outside. I do not do any.
No,
I do not do anything. Yes. Even that is covered under freedom of
conscience. No, all that distinction I'm saying is not. When you practice it outwardly, this word of Mr. Durgadas Basu, he says, he uses the word. I'll read it once again. It is a mental concept, while the right to profess, etc., refers to external action in pursuance of such mental concept of the individual. So that distinction is thin, but it's real. I must say, it is real.
conscience and religion are two different things.
Two things, conscience and religion. Therefore, they use the word freedom of conscience, right to practice religion.
One can be highly irreligious, but may have very conscientious.
Yes.
One may be very religious, but may not have the conscience.
Yeah.
How makers of the Constitution understood this?
Lord, this is there. I have got the Constitutional Assembly, but I wanted to place it before. Just one other paragraph after that. He continues there. It's a question.
Yes, that is very relevant.
Yes, Lord. Conscience, yes. Conscience and religion are thus different concepts. Conscience and religion are thus different concepts. And that is why both words are used in Article 18 of the Universal Declaration of Human Rights, 1948. The essence of the freedom of conscience is that it is a personal matter of the individual's own choice of the International Covenant on Political and Civil Rights. That freedom would be impaired if in the formation of the choice or change thereof, the free exercise of the individual's will is dominated or influenced by any other person. The mental aspect of the freedom of conscience must be remembered in any discussion under Article 25. Because of this guarantee of freedom of conscience, every person in India has an absolute right to form and adhere to his own belief in the matter of religion as in other matters. No one can therefore be compelled against his own judgment and belief to hold any particular creed. But No, in this Convenient 9. This test, this universal declaration. European.
All right, how to ascertain this conscience? We cannot follow me into the mind.
My reading of Vasu, what I would, that therefore uses the word, it is a mental concept.
How to ascertain?
No, I'm just coming. When you propagate, whatever be your belief, let us say, I'll take again the example of Buddhism itself. Let us say I believe Buddha is the one. Once I start exercising the practice of that religion, if I have to say so, then we come to the second one. Once you assert, you come into the realm of practice of religion.
That's true. What about how to ascertain? My question remains large again. Answer the question.
Answer the belief, your lordship.
Yes, conscience.
Answer the, of course, belief or non-belief also, it comes in the world. That's how they have described.
I say,
yes,
that saluting a particular symbol is contrary to my conscience. How to ascertain?
I'm assert or ascertain.
Ascertain. A-S-C-E-R-T-A-I-N.
Ascertain.
I'm not good in English because I'm not taught in
I understood it as assert, so that then the practice of religion, therefore.
How to investigate?
How to investigate
that conscience, what is the nature of conscience, whether conscience is at all there? How to ascertain? This only reminds me of some Shakespeare's poem. We cannot fathom into the mind of the man, though we can in the mind of the devil.
No, sir, I would, my lordships did ask me, how did the constitutional makers thought of it? But I will place it before you, in a particular order, maybe tomorrow, but I'll just state before a lot what happened. When Dr. Ambedkar introduced this, but I've seen that one. Some of the members opposed it, saying that time this concept of freedom of conscience was not there. They initially introduced it as right to propagate religion. The argument against this article was, no, you see, if you give this power, then there is a possibility of one religion being hegemonized over others. It is at that time Dr. Ambedkar intervenes and says, no, it does not just compel others to propagate and profess their religion over others. We also have freedom of conscience. That's how it develops, not that I'll place it. That seems to be, of course, with this concept which lordships are asking me, so surely not that how to ascertain. It is something which I possibly have to go a little bit read more on these aspects. But the freedom of conscience and right to propagate religion, the fundamental difference which Vasu makes I thought is a very simple thing. He says, whatever you believe, it stops at freedom of conscience. Once you manifest it outside, it becomes practice of religion. And convenient.
Now, in the light of this, what do you say whether hijab is part of?
Therefore, hijab certainly comes in the manifest exercise of right to practice. According to him, it's a right to practice of religion. That it's a right they are trying to exercise pursuant to the religion. This part two.
My lord's question.
We are on different question. Whether the hijab constitute the part of the essential religious practice or not?
But insofar as hijab being the part of essential religious practice, the answer is no. The answer is no. And why it is no, I'll possibly substantiate. Lordships, I can continue on Monday. Lordships.
All right. The Advocate General appearing on behalf of the respondent has placed his arguments in the record. The arguments of the Advocate General are continuing. Put up on Monday at 2:30.
Review of this court, I want to make one submission, Lord. Want to make one submission with review of this honorable court.
Yes.
Lord, this all writ petitions are private in nature, Lordship. And Lordship has passed the interim order considering the amending law and order situation at that point to that 11 The order has specifically in respect, para number 11, it is stated that it is only confined to those colleges where the CDC has been prescribed in uniform. But in spite of that, state has extended this order and enforced all the schools, degree colleges, all the colleges, Lordship. Even the schools, teachers also not spared.
Our order is very clear.
For that reason, Lordship, just one report may be called from the state how it has been implemented down. Because community, Muslim community members are facing so much difficulty because of this order, Lordship. And every department is interpreting in a different way altogether. Every department, even yesterday, minority department has passed the order. Even their schools, which are Urdu schools, 100% when the Muslim populations are there. Teachers, all Muslims are there. They are enforcing that order, Lordship. This is causing a lot of chaos in the society, Lordship. Because our purpose was to prevent law and order situation, but it is creating further, Lordship. And the police are deployed in front of the gate. They are forcing Muslim girls and they are threatening if they are not removing. The order was set that in the class, but in spite of that, in the gate itself, police personnel are deputed to threaten them, to intimidate them, to remove their burqa and scarf.
Yes, but Advocate General, you have
even the Kansas are not able to appreciate the I told convince
I do not want to enlarge this controversy, but I could have easily said, let them come with an evidence. All that I'll request him. Let him give me the details instead of the court. But we will instruct suitably to ensure that nobody acts beyond Lordship's interim order. But I'll assure your Lordship, there will be no cause of conflict. But provided not, he gives me the details in writing by way of a letter or something addressed to the advocate so that I can act.
I tell you my petitioners are uses like let him only let him not give affidavit. If I give affidavit, the question will raise.
Not Advocate General is saying, give whatever in writing, give your complaint in writing to him. He will instruct the authorities to act in accordance with the High Court's order only.
And let him be assured, there will be not even an inch.
Widely published in public media, in social media, all media houses, how
their stand is they are acting strictly in accordance with the High Court order.
That's the last for that reason I
feel that there any individual case there somebody is violating the order or acting more than what is mentioned in the order, then give it in writing, give the specific instance there, and they will act on it.
We will call the commission. I will ensure that it is done. Let him address a letter. In addition to this, some report also will be called from the state, Lordship.
On what basis?
Lordship, on the basis of implementation of the order, Lordship. The order was, purpose for the order to want a public order. Now it is creating divide in the society, Lordship. For that purpose only I am making submission.
All right, you file the application to consider.
Lordship, application, in which capacity I can file it? I am a petitioner, it's a private plea. It's a question creating chaos in the society. My humble submission, Lordship, if otherwise if Lordship will direct me to give a letter with all the proofs, I will provide it. I will submit it before the court also one copy that.
To him, he is very fair to the court. He is saying that he will act on it. Give it to him.
They are passing official orders, and even they are calling the minority institution, TDP, and they are telling them to enforce that order. And they say it's a High Court order. Everywhere they are quoting, even Education Minister says it's a High Court order. I really could not understand how they are interpreting, Lordship.
Very difficult to respond. Allegations are made against like this.
You implementing this orders in the schools will not.
Unless anything is happening before us, we cannot take cognizance of that.
Our situation is very tight. We have very limited scope to address our grievances, Lordship.
Thank you.
ಕ್ಲೇಮೆಂಟ್ ಇದೆ ಶಾಂತರಾಜ್ಗೆ ಅಂದ್ರೆ ಮೂರು ಪಿಟಿಷನ್ಸ್ ಸೀರಿಯಲ್ ನಂಬರ್ 25 to 27 ಒಬ್ಬರೇ ಕೌನ್ಸಿಲ್ ಅಲ್ಲ. ಶಾಂತರಾಜ್ ಕೆ ಹೆಗ್ಗಡೆ ಮುಕುಂದ
25.
ಈಗ ಫಸ್ಟ್ ಕೇಸಲ್ಲಿ ಹೆಗ್ಗಡೆ ಮುಕುಂದ್ ಫಾರ್ R2 ಅಂತಿದೆ. ರವೀಶ್ ಬೇರೆ ಬೇರೆ ಹಾ ಇಲ್ಲಿ ಇವರು ಶಾಂತರಾಜ್ ಅವ್ರು ಬರ್ತಾ ಇಲ್ವಾ? ಹೌದಾ? ಓಕೆ ಓಕೆ. ಅವ್ರೇನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರೆ ಏನಂತ? ಹೌದಾ? ಮೂರ್ ಮ್ಯಾಟರ್ಸ್ ಇದೆ ಅವ್ರದ್ದು, 25, 26, 27 ನೀವಿದ್ದೀರ. ತಿಳ್ಕೊಳ್ತೀರಾ ನೀವೇನಾದ್ರು ಅವ್ರಿಗೆ ಇವತ್ತು ಮಾಡ್ತೀನಿ ಅಂದ್ರೆ ಇಡೋಣ, ಅದರ್ವೈಸ್ ಬೇಸಿನ ಓಕೆ. ಪಾಸ್ವರ್ಡ್ ಮಾಡಿರಿ ನೋಡೋಣ ಸ್ವಲ್ಪ ಹೊತ್ತು. ಆಯ್ತು.
ಕೇಶವ ಪ್ರಶಾಂತ್
ಯಾರು? MC ಬಸವರಾಜು ಸರಸ್ವತಮ್ಮ ಇಸ್ ಪಾರ್ಟಿ ಅನ್ಸುತ್ತೆ. ಸರ್ಡ್ ಕೌನ್ಸಿಲ್ R1. ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಇಲ್ಲ. ಕೇಶವ ಪ್ರಶಾಂತ್ 28 ಅಲ್ಲ?
28.
No representation for both sides. Read list. ಇಪ್ಪತ್ತೆಂಟು 3.
29 ಶಾಂತರಾಜ್ ಸೇಮ್.
Appealing for respondent number 2, my lord, in this case. The claim petition dismissed.
Respondent number 2 is the insurance company, no?
ಹೌದು ಸ್ವಾಮಿ. ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ ಸ್ವಾಮಿ. ಇದ್ರಲ್ಲಿ ಅವ್ರು ಅಪೆಲೆಂಟ್ಸ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗ್ಬೇಕಿತ್ತಲ್ಲ. ಕೃಷ್ಣ ಸ್ವಾಮಿ ಪ್ರೇಸ್
You have been signed out because you are currently signed in on another device.
Okay.
ನಿಮಗೆ ಗೊತ್ತಿತ್ತು, ನನಗೆ ಅದೆಲ್ಲ ಗೊತ್ತಿಲ್ಲ. ಶಾಂತರಾಜ್ ಅವ್ರದ್ದು ಒಂದೆರಡು ಇಟ್ಕೊಂಡಿದ್ವಿ, ಅವ್ರೇನ್ ಬರ್ತಾರ ಅಂತ ಹೇಳಿ. Counsel for respondent number 2 is 29 alli. Respondent number 2 is present through VC. No representation for appellant. ಏನ್ ಮಾಡೋದಪ್ಪ, ಅಟ್ಲೀಸ್ಟ್ ರೆಡಿ ಅಂತ ಹೇಳಿದ್ರು ಪರವಾಗಿಲ್ಲ. 7-3 ವಕೀಲ್ರೆ.
30 ಸರಿತಾ ಕುಲಕರ್ಣಿ.
Mm.